Hello everyone. I'm going to make a video about property rights today. And that is a subject about which, to be absolutely frank, I never expected to make a video. You see, normally, when I at last decide that some subject is worthy of sitting down and recording a video and discussing at length as I am wont to do, generally, that subject is something which is not widely discussed, at least as far as YouTube is concerned. Ever since I started making videos, I've always tried to make the point that here on this channel, I would be discussing things that were not commonly discussed. The subjects of my videos would be subjects which, at least at the moment of their creation, would not be widely discussed. You see, I didn't want to make videos about subjects that countless other channels have already made countless other videos about, because if I had chosen to do that, I thought, there really wouldn't be much reason for anyone to watch my video or to pay any particular attention to what I have to say, or really to find anything of value or of interest there, because there were already so many other channels and so many other videos to choose from. There would be no way for me to distinguish myself. So I'd always said, well, if I'm going to discuss something, it's going to be something that any prospective viewers of any of my videos probably have not heard about or probably do not know much about. And from the moment at which I began to make videos, one of my other operating assumptions was that my audience consisted largely, perhaps even almost entirely, of libertarians, or at least libertarian-oriented people. And I suppose for a while that was true. However, recent events, especially in the wake of the Hangout marathon that I did a while ago, have impressed upon me the need to, as it were, go back to basics, to discuss certain things which, though to a libertarian audience might be obvious, might be well known, and might not need to be stressed, certainly are not so for people of other persuasions or other viewpoints. Now, what I'm referring to specifically is that I had done my very long 500 subscriber Q&A celebration, and then shortly thereafter I had actually sat down one day to do another live stream, simply to pass the time one day because I didn't have much of anything to do. And that stream is no longer up because, frankly, it wasn't something that was worthy of leaving up. But in the midst of the discussion that took place in the comments section, I had begun receiving all sorts of questions that I would have assumed that a libertarian audience would already know, and that therefore wouldn't be required, that it wouldn't be required to discuss. Of course, the assumption that I had a largely or even entirely libertarian audience, as that event revealed to me, may not be true. So, as I said, I'm going to discuss certain things that I never expected to talk about and that you could frankly find other videos about. But I've become aware of the need to go back to basics, to clean house, and dare I say it, to do some physical removal, so to speak. Now, don't get nervous. I'm not saying by that I'm going to, urge people to unsubscribe or kick them out or anything. It's just that there had been certain things I had assumed, certain working assumptions about what was true that just sort of informed everything that I was doing, and that I've now realized need to be fleshed out. So I'm going to do that with respect to property rights. And what I'm going to do in this video is just lay down certain ideas about property, and talk about various sorts of practical problems that could come up with regard to questions about assignment of property titles and so forth. Various practical situations. Now, of course, this discussion is not meant to be exhaustive by any means, and by no means could it be, because the sheer profusion of possible situations that could occur and possible problems that could be concocted, at least hypothetically, is endless. And so there's no way in which I could discuss every conceivable situation. However, my hope is that with the fair handful of basic notions that I'm going to lay down, once you've understood what they are and what their implications are, you could more or less, for just about any given hypothetical situation you could concoct, see your way to understanding how an approach informed by the principles that I'm going to lay down would deal with the situation in question. So basically what I'm going to do is lay out a libertarian or even sort of ANCAP theory of property. I'm going to argue for it, and I'm going to apply it to a certain number of practical situations and also deal with some objections. Now, there are various objections that could be made to the theory that I'm going to sketch out. Objections from the right, you could say, and objections from the left as well. Now, I'm not going to be dealing with those objections from the left because I don't think I have many left-wing subscribers, and so objections of that sort are not likely to come up. However, if for whatever reason you feel the need to make such objections, you can, of course, make them in the comments, and I will address them when I'm able to. Just be aware that they aren't going to be addressed in this video right here, because I just don't have the time for that. Now, before I begin, one final point I'd like to make. What I'm about to say here is going to be largely informed by the discussion found in Chapter 2 of this book, A Theory of Socialism and Capitalism by Hans-Hermann. I will, of course, as always, provide links in the description where you could go on Amazon or purchase the book, or even to a PDF, since I think that should be available for free as well. I'm also going to include links to various articles by Stefan Kinsella, who is sort of a follower of Hoppe and the next adopter and developer of his ideas. In particular, there's an article that he wrote called something like A Libertarian Theory of Contract and Title Transfer, something of that sort. I'm going to include a link to that article since it's very important as well. And perhaps some other things in addition to that. So, to begin the discussion, before I say anything else, let me set down a definition. And the definition is meant to answer the question, what does it mean to own something? What is ownership? Well, I define ownership as the right to exercise control, that is ultimate decision-making power, over some given scarce physical resource. So it's the right to exercise control, meaning ultimate decision-making power, over some scarce physical resource. Now, there are various terms in that definition, in particular scarce and physical resource, which will have to be expounded upon, and which will be expounded upon in the ensuing discussion. But I want to lay out this definition immediately because for what follows, it is important to keep it in mind. And so I'd like you all to sort of keep it in your heads, because this will come up repeatedly in what I'm about to say. All right, so given that that's what ownership is, the next question to ask, naturally, is what is the use of a theory of property, any theory of property? What is a theory of property, and why should societies address themselves to that question? Why does a social order require there to be some notions, some societal rules, some coherent theoretical construct, let's say, dealing with notions related to property? Well, remember, property rights are just titles to scarce physical goods, as I say. So why is that issue of importance at all? Why must any society deal with this question? Why must social theory address itself to it? And the reason is very simple. In reality, in the real world that we inhabit, there are all sorts of goods which can be put to all sorts of alternative uses. However, those goods are scarce. That is to say, their supply is limited. And not only is their supply limited, but given the fact that it is possible to put them to alternative uses, putting a good to any one particular use will often be mutually exclusive for other possible uses. That is, for many goods, virtually all of them, frankly, if you put some good to one use, you cannot always put it to some other use at the same time. For instance, if there is a car and I want to drive the car to one location, you want to drive it to another, and we both want to do what we want to do with the car in the moment at the same time. How are we to decide between ourselves which one of us has the right to use the car and to what end the car should be put? This is what the purpose of a system of property rights is. It's to resolve or even prevent, if possible, disagreements of this sort. So because goods are scarce in nature and because they can be put to alternative uses, conflicts relating to how they are to be used inevitably will emerge. In order to resolve these conflicts, we need some system of rules which clearly and unambiguously states who, in any given case of conflict concerning the use of some scarce physical resource, is right and who is wrong, who does have the right to put it to the use that they want to put it to, and who does not have that right. That is what a system of property rights is meant to do. And this is true for all systems of property rights, regardless of their character and their details. All systems of property rights are meant to address that question. That is why a theory of property is necessary to inform the functioning of any society. So, with that in mind, the following question, the question that follows afterward naturally in its train, is what sort of theory of property should be adopted by society? What is the correct one or the best one or the optimal one, let's say? Well, before I address that question in any detail, I'd like to impress further upon all of you how truly pervasive this fact of scarcity is, and how deeply severe and pressing the necessity for some system of allocation of property rights titles is. And you can see this with a deliberately extreme hypothetical example. And this example is obviously not meant to it's not meant to be compared to actual empirical reality, because it will be deliberately constructed in such a way as to make it contrary to empirical reality. But nevertheless, the conclusions that we draw from it can be used to inform what we do and what sort of property rights system we ultimately decide to set up in the real world. And the hypothetical example is this. Suppose that we live in the Garden of Eden. In the Garden of Eden, goods are superabundant. If you choose to pick an apple off of a tree and eat it, this act in no way diminishes the total supply of apples, and in no way makes it any more difficult for me or for anyone else to also pick apples from the same tree or some other tree or what have you, and similarly enjoy them. The supply of goods in the Garden of Eden is not scarce. Anyone who makes use of any particular good does not thereby exclude another person from using it, since the other person can take advantage of this situation of superabundance and simply, you could even say just by willing it or just by wishing for it, procure for himself a segment of whatever goods he happens to require to do whatever he happens to want to do with them. However, even in this fantastical situation, there are nevertheless limitations to contend with. If by nothing else, you are limited by the borders of your own body. So you cannot, for example, even in the Garden of Eden, be in two places at once. You have a limited physical body with limited capacities that over time will grow older and will die and will decay. And so you're limited by the physical limitations of your body, but your time is also limited in that you're aging, and there's a limited amount of time there for you to do all of the things that you would like to do. So you still have to deal with the fact of scarcity, even in that limited sense. You're also limited in terms of your standing room and various other things. So the limitations in this hypothetical example of the Garden of Eden are nowhere near as severe as the limitations of the actual world. However, there are nevertheless some limitations, and there is nevertheless some degree of scarcity prevailing even there. And so even there, if only to a limited extent, some theory of property is necessary to work out various conflicts that could emerge. If each person's body is nevertheless is a scarce physical resource, even in the Garden of Eden, then there has to be some ideas about how to allocate property titles to those, and to say who may legitimately use whose body for what purpose, when, and under what conditions, etc., etc. Because again, the ultimate purpose of a system of property rights is to avoid or prevent conflicts that may arise over the use of scarce physical resources. So, in this Garden of Eden situation, we see that even with a superabundance of most of the things that we are accustomed to thinking of as goods, there nevertheless prevails a certain amount of scarcity with regard to time, with regard to the physical limitations of our bodies, and so forth. And so even in this hypothetical, fantastical, exaggerated situation, some system of property rights remains nevertheless necessary. And so if there is a necessity for such a system, even in this idealized situation, how much more necessary is a system of property rights in the real world, which is subject to much greater, much more severe, much more stringent limitations. All right, now let's do one final thing with the Garden of Eden case before we move on to something more realistic. Given that people's physical bodies in the Garden of Eden are limited, are scarce, and cannot be necessarily put to multiple uses simultaneously, questions will inevitably emerge about what uses whose body is to be put to at which particular time, and who is to make the decisions, who is to exercise the control, the ultimate decision-making power, over what those decisions are to be, how they are to be made, and so forth. Now, what I'm going to call the natural position, that is the natural way to answer this question, is as follows. That each individual person, being tied necessarily in some metaphysical sense to his own body, has a claim that takes priority over that of anyone else, over his body and the uses to which it is to be put. Now, I refer to this as the natural position, but I don't want, for the moment, anyone to draw the conclusion that by calling this the natural position, I am ascribing some kind of evaluation, a moral evaluation, if you will, to this idea. It's just simply a term of description. I intend the term natural to be purely descriptive. If you don't like the term, you can use any other term that you like, but I simply want there to be something that I could use to easily and simply refer to the position that I've sketched out. That each person associated in whatever sense, whatever metaphysical theory of the self and of connection between mind and body you happen to have or happen to believe in, there is nevertheless this fact that each person somehow is ineluctably associated with a particular body, and I argue that that fact gives that person a stronger claim over the use of his own body than anyone else. Now, what is the reason for this? Well, suppose that it were otherwise. Suppose that the proposal for how to allocate titles to the use of the scarce good bodies, physical bodies, were other than that. Suppose, for example, that bodies were under universal collective ownership. That is, that everyone had ultimate decision-making power about what was to be done at any particular time with any given physical body. Well, this would be an enormously impractical system. The obvious reason for that being that under such a system, before anyone could do anything at all, make any movement, make any sound, do anything whatsoever with his own body, he would have to procure the permission of everyone else to do it. But of course, to procure that permission, you would be required to make use of your body. There's no way around that problem. It's just a feature of reality and how humans happen to be constituted. And so there would be no way to legitimately do things under such a system. And if there is no way to legitimately do anything at all under such a system, then the only way to act in a way that is consistent with it is to essentially sit there and do nothing and wait as the entire human race slowly dies off. So by consistently following that suggestion, we are led to the extinction of the human race. We are led to the extinction of humanity. And I would say, it's entirely fair to say, I think, that any system of property rights and any ethic at all, really, which, as one of its logical implications, leads to the universal extinction of humanity, is a bad system of property rights allocation, or is a bad ethic generally, and should for that reason be rejected. So we can't do this thing with universal collective ownership. But even if we're not talking about universal collective ownership, remember, as I said earlier, ownership is the right to exercise ultimate decision-making power over some given scarce resource. And if we are to say that someone other than the person which is ineluctably connected with some given body is to be the one to exercise ultimate decision-making power over it, then that person which is so connected to the body can't do anything without asking some other person, whoever that owner may be. Now, of course, the act of asking permission is, again, itself an act which requires the use of one's body. So it would be impossible to procure permission to do anything. And again, we have this problem. So I think the natural position that each person having this natural connection to his own body is to be considered the owner of it, is to be, the person to exercise ultimate control, ultimate decision-making power over its use. So it has a lot to be said. There's a lot to be said in favor of this position. It's very intuitive. This is what I mean to say. Now, a further consideration and a further argument to defend this view can be seen as soon as we move outside of the Garden of Eden and bring ourselves under consideration, under some situation that is more realistic. So imagine, more essentially a real world where goods really are scarce, unlike in the Garden of Eden. Then there would be questions regarding the use of scarce physical resources that pertain not just to the physical bodies of all the people involved, but also to the goods that they may wish to make use of. So, if there is some good that is, let's say, unowned, no one is doing anything with it, no one is making use of it in any way, and it is assumed to be unowned, how may it legitimately come to be under the ownership of someone? Well, I claim that the way to bring an unowned good under ownership is to be the first person to make use of it, and upon making use of it, what you must do in order to state, solidify, or demonstrate your claim to it as the owner is to do something to alter the physical character of the good in such a way that what you have done is intersubjectively ascertainable. So you do something to alter the physical state or the physical character of the good in question, And your change, your transformation, is such that it can be ascertained and understood and seen and clearly perceived by the other people around you in society. So let's say, for example, that there is some plot of land, it is unowned, no one is there, no one is doing anything with it. You come upon this plot of land and you fence off a portion of it, or you cultivate some of the land and begin to grow crops there that previously were not growing. Now, other people who come along can see your fence, and they know that the fence was not there. This is an intersubjectively ascertainable fact. Previously, there was no fence. Now there is. Previously, there were no crops growing. Now there are crops growing. You have done something to alter the physical character of the good in question, and that thing that you've done is intersubjectively ascertainable. It's a physical transformation. Now, what I have just laid out is different in subtle ways from the well-known Lockean criterion for what the proper way of appropriating an unowned resource is, that whole labor mixture criterion. The problem with the original Lockean criterion is that it is vague. What does it mean to mix your labor with something? Well, it's difficult to say. The statement also conjures up thoughts that there is this thing called labor, which is associated to some person, which is measurable and can be expended in various quantities, and that by applying a certain quantity of this thing called labor to this good, one appropriates it, one brings it under his ownership. But of course, what does it mean to speak of quantities of labor? What does it mean to say that there is a thing called labor which is somehow measurable and so forth? These questions don't seem to be answerable. And so if you approach the problem of how to legitimately appropriate unowned property using this essentially metaphorical Lockean labor mixture criterion, you get into all sorts of thorny issues, all sorts of issues of vagueness that cannot be easily or clearly resolved. On the other hand, if you use the criterion that I have suggested, in which an intersubjectively ascertainable physical transformation must be made to the resource in question by the person claiming to own it, and that person must, of course, in addition, be the first person to make such a to be responsible for such a physical transformation. Well, that's different. You see, all the problems of vagueness disappear. If the transformation is physical, if it's intersubjectively ascertainable, it can therefore be acknowledged and deemed valid by the other people in society with whom the prospective owner lives. So this specification of physical transformation that is intersubjectively ascertainable gets around these vagueness issues regarding the original Lockean labor mixture criterion. Now, to pause for a moment and apply this claim to the question of ownership over one's physical body, it is clear and it is obvious that of the nature of things, there exists a connection between each person and his body. He is able to exercise control over it in various ways. And he is able to do so immediately, from birth. Immediately, fresh out of the womb, you can see a baby crying or flailing its limbs around, doing all sorts of things with its own body. This connection is immediate, and so if we were to regard, just hypothetically, some hypothetical situation in which physical human bodies are unowned, scarce resources, like any other scarce resource, upon birth, you can see that some person is making use of that body and doing things to it and altering its character physically in all sorts of ways. And because you can see this fact is intersubjectively ascertainable. You can see the baby, fresh out of the womb, flailing around and doing all sorts of things. And so if you want to think of it in those terms, you can then say that because what we see even small newborn babies doing to their bodies fits this appropriation criterion that I've outlined, where you must be the first person to do something to physically transform a resource in some intersubjectively ascertainable way, that then also gives you an argument in favor of the self-ownership position. That is, that each person owns himself, owns his own physical body. Now, another point that should be considered. There is, nevertheless, despite this similarity that I've just talked about, a very important difference between one's own body and any other physical resource that one could come to own in this way. And the difference is that if I own some plot of land, and I decide that I no longer have any use for this plot of land, I can choose to sell it to someone else. That is, arrange a contractual agreement where I decide to transfer the ownership title over that parcel of land to someone else in exchange for something, or perhaps to give it to them as a gift for, in exchange for no other property title to anything, depending on what I wish to do. I could do that, or I could simply choose to abandon the land in question and leave it to the ravages of nature because I no longer care for it. Now, it is clearly legitimate and acceptable for an owner to abandon, to give up the right to his own property if he should choose to do so. The question, however, is how long must the property remain in this state of abandonment or disuse? For how long must I have chosen not to do anything to my parcel of land before it goes back into nature, so to speak, and becomes once again an unowned resource? Well, there's no non-arbitrary answer to this question. There is no definite answer, and it does not make sense to set down any definite answer. However, what I think can be said is that within any given society, there does emerge naturally a sort of consensus about various norms. Certain, various customs emerge, various things about the normative order prevailing in that society that are simply understood by the members of that society. And that question of how long must a good be in a state of abandonment before it once again becomes unowned and before the previous owner relinquishes title to it, that's something that will just be decided in one manner or another by the society in question. It could be by the courts, it could be in some other way, but the point is, sooner or later, everyone will have to pick some number, some length of time. It can't be, let's say, one day. You can't leave the plot of land that you own for a day and then have it be said that you no longer own it. But it also can't be, 1,000 years or something like this. So some arbitrary point, and I freely admit that it's arbitrary, will be chosen by the society in one way or another, and that will be the point at which it is agreed that if the resource is abandoned for longer than this amount of time, it will then be considered to be unowned once again. Now, it does not matter for my purposes what length of time is chosen. The only thing that matters is that some length of time is chosen, as it will be, because the question will inevitably emerge in any given society sooner or later. Now, although it is clearly possible in this way to abandon title to various goods. One cannot in the same way abandon title to one's own body. You cannot relinquish your own ability to control your own movements, for example. It's just not possible to do this. Humans are simply not constituted in this way. We cannot will ourselves to inhabit some other body and exercise control over it rather than our own, and in so doing abandon our previous body and just leave it in this sort of zombified state. I mean, who knows? There could be all sorts of future transhumanist-like technologies that may allow us to inhabit different bodies. Without speculating on those possibilities, the fact of the matter remains that as things currently stand right now, it is simply not possible to abandon one's own body in the way that one can abandon any other given resource. And so, because of this, there's an important distinction to be made between one's own body and everything else. That is, all other resources are alienable, which is to say they can be abandoned in the way described, but the body is not. You cannot, even if you wanted to, relinquish control over yourself in that sort of required way. You cannot relinquish ultimate decision-making power over your own movements, over what to do with yourself, and so forth. There just is this natural, apparently ineradicable connection between yourself and your body in a way that simply doesn't exist between yourself and any other resource. So the important thing about the body is that it's not alienable. And one of the practical conclusions of that is that something like slavery immediately becomes illegitimate, because it's just not possible in the nature of things for another person to for one person to exercise ultimate decision-making power over another. You can threaten another person into complying with your wishes, but you cannot directly, by way of your own will, control what they do. That's just not possible. That's not how human beings are. That's not how the connection between the self or the soul and the body is forged. It's just not the way things are. And if you don't believe in a soul, or if you find metaphysical doctrines about those sorts of things controversial, you could just as easily say, you could take, for instance, a materialist route and say that you are your own body in some sense. And for the purposes of what I'm talking about here, that would be fine as well. So really, the particular metaphysics of the self and of personhood that you happen to favor don't really make a difference to the conclusions laid out here. So that's one important difference between the body and every other good. Now, given this idea about you having the strongest and most natural claim to owning yourself, and given the idea that the first person to do something to physically transform some unowned resource in an intersubjectively ascertainable way then becomes the owner of it, what social conclusions follow? Oh, and by the way, if that notion is still controversial to you, I ask you to perform a thought experiment. Imagine some other criterion for how it is that one could legitimately acquire ownership over unowned resources. I mentioned the criterion of, well, imagine that everyone owns everything. Well, then you would have to ask permission of everyone before you could do anything with anything. Imagine that it's not the first person to physically transform the resource that becomes the owner, but the second person, or the fifth person, or the 10th person, or anything but the first person. In that situation, there would be no incentive present for the people coming before whatever the magic number that you have chosen is to do anything to the resource in question, because they would not be able to reap for themselves the benefits of owning that resource. And so there'd just be no reason for anyone to do anything to physically transform a resource or do anything to it. No one would then, if acting consistently with this system of property norms, do anything to any piece of property, would not make use of it, and therefore humanity would not be able to procure for itself the things that it needs to carry on its own existence, and humanity would once again die off, making that sort of an arrangement illegitimate. Now, there are further questions that could be asked. Perhaps we could have notions of collective ownership that are different. For example, there could be a lake, let's say, and rather than some one particular person being the sole owner and proprietor of the lake, ownership rights to the lake could be extended to an entire village, the village where the lake happens to be located, and so forth. There are ways to do things like that within the system that I'm advocating here, and in a moment I will discuss those. However, before I turn to that question, there's one other thing that needs to be addressed. So, now, given the criteria of legitimate appropriation of property that I've laid out, what then is to be said about those who do not respect the ownership rights of others that have been acquired in this way? For example, let's say there's some plot of land, no one is making use of it, I do something to physically alter the land, like fencing it off or growing crops on it, I become the owner, and I do as I like with it because I'm the owner, but then someone else comes along who wants to put the land to some other use, and he puts it to that use against my will or against my objections. Behavior like that is, in this system, to be considered aggression. Now again, the term aggression is not to be understood as having any kind of evaluative connotations just yet. This is simply a descriptive term. This is what I'm calling aggression, the act of someone putting resources that are legitimately owned by someone else to uses that they want to put them to, as opposed to the uses that the legitimate owner wants to put them to. So that's what's called aggression. Now, to further specify this concept, it should be said that the only thing that can count as aggression under this kind of system is when you put the legitimately owned property of someone else to a use that is sort of physically evident, meaning that the use to which you put it does something to alter the physical character of the resource in question. Either you physically damage the resource, I don't know, let's say I own a plot of land and you come in and you sow it with salt, or you burn down my crops or something. Only those things, only things which alter the physical character of the resource are to be considered aggressions. And it is not legitimate, it is not acceptable to simply say that doing something either to or doing something either to one's body or that affects anything that one owns that does not alter the physical constitution and nature of that thing, but that simply happens to offend the sensibilities of the owner, or that goes against the beliefs of the owner, or anything like this. Such things cannot be termed aggression. And the reason they cannot be termed aggression is that if I am interacting with you, I do not necessarily know what your beliefs are, what you happen to find offensive, and so forth. And so if simply saying things that offend your sensibilities or that you don't like, for example, is to be treated as aggression and therefore presumably a criminal offense, it is never possible for me to know ex ante in every situation whether what I am doing is to be considered aggressive or criminal or not. On the other hand, if I see that there is some physical resource that you own and that you have established intersubjectively ascertainable and clear borders around, then I know what the line is that I can't cross. I know exactly where your property begins. And so it is clear then what in that instance would count as aggression, because it's not based on your beliefs or your subjective whims or any personal subjective feature that you have that I may not be privy to. On the other hand, I am privy to the borders of your property because they exist they're manifested in physical reality, they're intersubjectively ascertainable, and I know where they are. And so it is always possible for me ex ante to determine whether any particular action that I may undertake would trespass on the borders of your property or not. And so it's only physically altering the legitimate property of someone else, physically damaging it in some way, that counts as aggression. Because it's the only sort of thing that can be determined as aggression ex ante. And that's important, because if you can't determine ex ante whether something is aggression or criminal or prohibited or not, then when you're contemplating to undertake some action, you can never know ahead of time whether what you're doing is legitimate or not. And therefore you can't know whether you should do it or not. And that imposes a straitjacket on your action that could make doing anything impractical or impossible, and would again impose these constraints that could, if followed through consistently, lead to the extinction of humanity. So, with that having been explained, and one further point too, I have been focusing on this criterion of physically doing something to the property that you wish to appropriate. Now, that is important for a further reason. Not only because it makes it possible ex ante to determine what is aggressive or not, but also because any other notion of how to legitimately acquire or appropriate property would not be fit for purpose, given what the ultimate aim and purpose of any property rights system is supposed to be, namely to resolve or prevent possible conflicts in the use of scarce resources between two people with conflicting claims over them. Suppose that in order to appropriate an unowned resource, rather than having to do something to physically transform the resource in an intersubjectively ascertainable way, it were enough for me simply to verbally declare that I own the resource in question. Well, if that were enough, then I could make my verbal declaration, and someone else could make his verbal declaration, and a third person could make his, and so forth. And each of our verbal declarations presumably would be equally valid, and so we would then each enter into a disagreement about what to do with the resource in question, and that would be a conflict, and there would be no way to resolve the conflict. So again, any system of property rights that counsels something like that is not fit for purpose. So, all right, with all of this having been established, now let's turn to the question of certain practical applications. Now, I had mentioned that I was going to discuss various ideas about what can loosely be called collective ownership. I want to be careful with this term, because and to be honest, I don't really like it, because it's very easy to introduce confusions and problems if one adopts this approach. But I'm going to go with it for now, and hopefully try to say what I'm about to say as clearly as I can, so as to prevent any possible confusions from emerging. Now, I had said earlier that the way for someone to appropriate an unowned resource is to be the first person who does something to physically transform the resource in an intersubjectively ascertainable way, either by establishing a border or doing something to it, and so on. But one can conceivably envisage cases, for example, where there is, let's say, a village of people. There's a lake in the village, and the villagers all collectively make use of this lake. They bathe in it, or they take water from it, and it's whatever you like. They make use of the lake for some purpose. And the villagers all collectively arrive at the lake at about the same time, and it is not possible to determine who exactly the first person was who made some physical change to the resource. And so you cannot pinpoint one person and only one person as the owner. Is it permissible then to say that the villagers have some sort of collective ownership right to this lake under this libertarian property rights system that I've proposed? Well, my answer is yes, but the answer has to be qualified in various ways. Remember that the villagers, when coming upon this lake in our example, proceeded to do something to it. So they did fulfill the appropriation criterion that involves physically altering the resource in some intersubjectively ascertainable way. And as the villagers continue to make use of this resource, it is obviously intersubjectively ascertainable and clear to them that they are the ones using it, that they are the legitimate owners of it. But in what sense are they the legitimate owners? All right, now let's go back to the definition of ownership that I gave in the beginning. I had said that ownership is the right to control some given scarce physical resource. The term scarce is important because for any good that is not scarce, it is not possible for conflicts about its use to emerge, and so you don't need a system of property rights to allocate titles to that good. And the word physical is important because we need intersubjectively ascertainable physical borders that make it possible for us to determine ex ante what sort of behavior is aggressive and illegitimate and what isn't. And also because it allows us to get around various vagueness problems such as those emerging from the Lockean labor mixture criterion. So ownership is the right to control some given scarce physical resource, control being the right of ultimate decision-making power. Now let's suppose that some group of villagers, let's say there are 50 of them, they all collectively have been making use of this lake from the beginning, but some disagreement emerges one day between them about the use to which the lake should be put in the future. Let's say that some villagers are willing to allow outsiders to bathe in the lake provided that the outsiders pay a fee to do it, and other villagers are not willing to allow this. And they say only that the inhabitants of the village and no one else may bathe in the lake, and everyone else is to be excluded, whether they are willing to pay a fee for the privilege of bathing in the lake or doing whatever else with it or not. How then is this conflict to be resolved? Well, it doesn't resolve the conflict simply to say that the villagers collectively own the land. Now, you could perhaps create some system in which each of the 50 villagers are assigned shares of ownership in the lake. So because, let's say, there are 50 villagers, they're each given one of 50 shares of ownership in the lake, and so they each have 1/50th of an ownership share. And you can then allocate and arrange ownership to the lake in a way similar to how ownership over corporations, with regard to the stock that corporations issue, you can organize ownership of the lake or of any other given resource in a way like that. And that would be legitimate in this libertarian system. However, the problem nevertheless emerges even in this case, where individual villagers own the resource that is their share. So rather than the lake itself being considered the resource in question, it is the shares that are each resources. So I just want to make this clear. If you agree to split up the lake into 50 shares and assign ownership shares to each of the 50 villagers in a way just like how shares of ownership in companies are arranged, then the good in question becomes not the lake itself but the shares. And so each individual villager becomes the owner of his share and is able to exercise ultimate decision-making power over what he is to do with that share. He can sell it, he can abandon it, he can give it as a gift to someone else, etc. But in the situation where there is a conflict between the villagers over what to do, there must be some way to resolve this conflict. So something about the ownership agreement established by the villagers over the lake must exist in order to handle conflicts of this sort, because they inevitably will emerge. It is simply not realistic to imagine that all of the villagers will agree in perpetuity about what is to be done with their lake. And there could be any number of ways in which conflicts of this nature could be resolved. And those conflicts would be specified in the ownership agreements, which is to say the contracts between the villagers. And these could be anything. So, for instance, one thing to do would be to have a vote. And each villager would then have his vote count in proportion to how many shares he owns. So if everyone owns one of the 50 shares, his vote counts equally, but if at some point one villager decides, you know what, I don't really want my shares, and chooses to sell it to some other villager, that other villager will then have a vote that carries more weight, and so on. Or you could arrange it in some other way. The specific details of the arrangement don't matter. The point is simply that some arrangement must exist, because if it doesn't, conflicts of that sort will emerge. And again, the point of a system of property rights is to resolve or prevent conflicts about the use to which scarce physical resources may be put. So, let's just go with the example of majority vote among shareholders. Let's say that the majority votes in favor of admitting outsiders. Well, what happens then is that if the agreement says that what we should do with the lake in a case of disagreement is whatever the majority of shareholders voting in proportion to the number of shares they own declare that must be done, well, then that, in effect, is who the owner is. It's the majority of shareholders who are the owner, not the village as a whole, because it's the majority that is exercising the decision-making power. The buck stops with the majority. In cases of disagreement or confusion over what is to be done, it's the majority that ultimately resolves the conflict and ultimately decides what is to be done with the lake. Another possible arrangement could be something like, and again, as I say, it doesn't really matter. Let's say that the villagers decide to hold, a chess tournament. And the winner of the chess tournament, the one person who wins, he gets to decide what is to be done with the lake in cases of disagreement. Well, then, what becomes the case then is that the winner of the chess tournament is the de facto owner. He is the one who gets to exercise ultimate decision-making power. You see, let me give another example. Let's go back to the example of the car, where one person wants to use it to travel to one location and another wants to use it to travel to the other, and they get into an argument over this. Well, however that conflict is resolved, whoever wins, whoever the decision is reached in favor of, is the de facto owner of the car. Now, that can still be the case even if you have something like ownership shares in the car being distributed equally between the two people. And the reason you can have that is that that's just what ownership is, as I defined it in the beginning. Ownership is the right to exercise ultimate decision-making power over the use to which some given physical resource is to be put. So if there are multiple people who own a resource and they disagree, and none of them really exercises ultimate decision-making power, well, then they're not owners in that sense. They have a sort of a weaker claim. But it would be the specifics of the contract or the agreement between them that would explain the conditions under which and under which and how and for what purpose and when and so forth, some person or other would exercise ultimate decision-making power over the resource. See, when you say ultimate decision-making power, you are always, in effect, bringing things down to some place where the buck finally stops. And that could be either with some particular individual with some goals of his own in mind, or some body of individuals which collectively and unanimously happen to agree on some given use. So in the example of disagreements being settled by majority vote, the body in question is the majority, and that majority happens to agree unanimously within its among itself, within itself, on the use to which the lake is to be put. And in the case of how to use the car, let's say there's some procedure. Let's say the two people play a chess game, and whoever wins gets to use the car for his purposes. Well, then it's the winner of the chess game who exercises ultimate decision-making power. That's where the buck stops. So the problem with simply saying that people can collectively own a resource and then not saying anything in addition to that is that simply declaring that doesn't do anything to resolve possible conflicts that could emerge about what use to put that resource to. And the only way to resolve those conflicts is to have it be specified in the ownership agreement what is to be done. And when those conditions are fulfilled, there will always necessarily emerge some single individual or some unanimous body of individuals which agrees to put the resource to some given use. That just follows from the definition of control and from the definition of ownership. If there's a body of people who collectively own something and they disagree, well, then not all of them own it. There needs to be some procedure to determine who is right and who is wrong in this disagreement, and whoever is determined by that procedure to be right, that person or group of people is the de facto owner. Always. All collective systems of ownership devolve down to this eventually, because there's simply no other way, ultimately and in the final analysis, to make decisions about what to do with goods. So before I conclude this video, let me treat a few practical problems. So let's go back to the case of our villagers and their lake. And let's say that they do collectively own the lake in some sense. That is, that they have shares. And those shares give them the right to vote in elections that are meant to resolve disagreements about the use to which to put the lake, and whatever other conditions you like. The details don't matter. But let's say that in that sense, the villagers collectively own the lake. Well, let's suppose someone comes along, some outsider from the village, and begins to dump toxic waste into the lake. He has now encroached on the property rights of the villagers. And so the villagers may legitimately sue him or otherwise detain him or extract damages from this person, or whoever it is that's ultimately responsible for what he did, if he was maybe put up to it by someone else, et cetera, et cetera. These sort of details aren't really important. But the point is that because in this case you do have a situation where villagers collectively appropriated the lake, that is, they together began doing things to physically alter the character of the lake in an intersubjectively ascertainable way, and because an agreement was worked out between them over the assignment of ownership shares in this lake and what's to be done in cases of disagreement about what to do with the lake between them, and so forth, this person who's dumped toxic waste into the lake has encroached on the property rights of the villagers. So it is legitimate to hold this person accountable and to extract damages to him, and a court could rule something like that the person has to pay a certain amount in damages, and then the total pie of damages is to be allocated among the villager shareholders in proportion to how many shares each villager happens to own, or any other agreement. It really does. Again, it doesn't matter what the specifics of it are, but the point is simply that you will have some system of rules that always produces some determinate and unambiguous result for you. Now, you can ask the question, well, what if the villagers didn't work out this kind of specific agreement about shareholding and all of this? Well, that doesn't strike me as very likely. I mean, surely there will eventually, sooner or later, emerge disagreements between the villagers about what to do with the lake that they collectively own. And there has to be some set of rules in place to resolve these conflicts, don't you think? And if there is some set of rules to do that, well, then those rules would presumably be applied to the situation that I just described, where some outsider dumps toxic waste into the lake. So the system that I'm proposing can deal with these sorts of cases. There is some notion of the commons, if you like, that is admissible here. However, we have to bear in mind that you cannot simply say that some group of people collectively own something and then you cannot say anything further. There will always be possibility for conflict about the use to which to put the resource, and some procedure, some set of rules has to exist to resolve that conflict. Whoever it is that, according to those rules, comes out as being in the right in that disagreement is always the de facto owner, is always the person or group of people who owns the resource, even if you want to say that some other group collectively or nominally owns, quote unquote, the resource in question. And this is really not that wacky, because actually existing law and precedent and so forth relating to corporations, relating to publicly traded companies that sell shares to the public, is rather like what I've described. If you own some shares of Google's stock, does that entitle you to make decisions about what Google does unilaterally, all on your own? May you fly on Google's corporate jet? No, you can't do any of these things. In fact, it's explained in any shareholders agreement that you'd care to consult that owning shares in a corporation allows you to collect revenue, dividends and so forth, and it also allows you to vote in elections on who is to be appointed to the board of directors. That's what ownership shares in Google or any other company allow you to do. Now, the board of directors, though, appoint managers, and the managers are responsible to the board, and the managers are the ones who make decisions about what the company is to do. So there are other people, not the shareholders necessarily, although in some cases that may be possible, but for the typical shareholder in a company like Google or any other company, that shareholder is not the one who exercises ultimate decision-making power over what the company is to do with its resources. So the shareholder can be said to be a nominal owner, but he's not a real owner. And you could perhaps make that sort of distinction between nominal ownership and real ownership. But from a libertarian perspective, from the perspective of the property rights theory that I've outlined here, what matters is the real ownership, who it is that exercises ultimate decision-making power over some given scarce resource. So I hope that makes clear what I believe about property and what I think is the correct way to sort of resolve these conflicts that could emerge over their use. I do not see how any other system could be effective in resolving conflict, because, as I said, it's not enough simply to declare that some group of people collectively owns some resource. I mean, there could be further complications. If you simply wish to say that villagers collectively own some lake, and then, that's it, nothing more to be said. Well, what happens if certain villagers die of old age and other villagers are born? Are ownership titles reshuffled constantly? What if some new person moves to the village? When do they acquire ownership? These things will have to be worked out in agreements because they're very real practical problems. So it's just, it's not honest, I think, to construct a hypothetical case in which answers to these problems have not been worked out, because they are problems that will naturally emerge, that are bound to emerge, and that have to be resolved when they emerge by any decent, respectable system of property rights that wants to preserve order and really fulfill the purpose of a system of property rights, which is to resolve or prevent conflicts over the use of scarce physical resources. So that's really all I'd like to say about property in general, and I think that those general remarks should be sufficient to make it clear to anyone what should be done in any given hypothetical case that you'd like to construct. And as I said, I'm really not going to bother to go through too many of those because they're just too many. The examples are endless. However, if it's not clear to you how to apply what I've said to whatever case you happen to be thinking of, feel free to offer me your suggestions in the comments, and I will do my best to address the problem. However, as I said, I think that what's been outlined is sufficient. So the owner of, to recapitulate one final time, the owner of a previously unowned good becomes the owner when he is the first person to physically alter the character of the resource in question in an intersubjectively ascertainable way. And once someone has appropriated the good in that way, they can either sell it to someone else in some sort of contractual agreement in exchange for some other piece of property, or they can give it away to someone else as a gift. And all of the specifics and conditions of that would fall under a theory of contracts. And by the way, just as an aside, the theory of contracts that I think is the legitimate one, the libertarian one, is one that says that contracts are, that is, legitimately enforceable contracts, are contracts involving the transfer of titles to property. Not every promise is enforceable, and so not every promise can be deemed a contractual promise. For example, if I promise to come over to your house over the weekend and watch a movie with you, but then I decide not to come, it would be rather absurd to say that you have the right to drag me into court and sue me because I made a promise to you and didn't keep it. Not every promise is enforceable. That's clear. And so as far as legitimate contracts go, enforceable promises, as far as those go, the only ones that are enforceable are those that involve transfers of property. And many of these transfers can be conditional. So for example, let's say that I hire someone to sing at a wedding, and the singer doesn't show up and doesn't perform their expected service. Well, it can be specified in the contract that there will be various conditional transfers of property that take place. So the contract can go as follows. On the condition that the singer shows up and sings as is being requested, he will be paid such and such amount of money. So given some condition, namely the singer showing up and singing, the contract specifies that X dollars, that being the property in question, will be transferred to the singer. However, in the event that the singer does not show up, does not sing, does not perform the service that is requested of him, the condition that will obtain is that a certain amount of money is to be transferred from the singer to the person with whom, the person requesting his services. So there's this conditional transfer of property. If one condition holds, one particular transfer of property occurs. If another condition holds, another transfer of property occurs. And you can explain things like that and cover situations like the singer not showing up to sing at a wedding, or virtually anything else that you can conceive of in that way. If you just think of contracts as promises involving conditional transfers of rights to property. Right, so that's all I should say about contracts there. But that should be enough, really, to explain what I think about property rights and show that the system that I advocate is adequate to solving the problem of how to unambiguously and clearly resolve all conflicts in the use of scarce physical resources between people. And by being able to resolve those conflicts, it is conducive to social order, to social stability, and so forth, and therefore is a good thing. Now, one final comment I should make, because there could be lingering skeptics here, will say, well, why should we universally agree to this set of rules? Why would it not be possible for, say, or permissible rather, for some organization to let's say, take a certain amount of the property of someone else and distribute it to other people, or do something of that sort? Well, in that situation, what happens is that the organization doing the distributing is allowed to, at least some degree, to systematically violate the property rights of others, property rights being those that I've just explained. Now, in a system in which property rights violations are permissible in that way, you will, as a consequence, subject people to different incentives. You will subject them to a set of incentives that they would not be subject to had their property rights been universally secure. Here's what I mean by this. Suppose that your property rights were ironclad. That is, anyone who took your legitimate property from you for any reason which you did not approve of and you did not grant permission for would be prosecuted as an aggressor and a criminal, including even, let's say, the state itself or the organization calling it the state. If that were allowed, then those would be, if that were the norm, then those conditions would be such as would enable you to make use of or exploit, if you will, the full fruits of what you happen to own. If you're able to exploit the full fruits of your property, you are much more likely to think ahead, to plan, to save, and to engage in long-term production projects that are likely in the long run to yield a higher yield, but which are more difficult to undertake because they require time and sacrifice and so forth. Conversely, if systematic violations of property rights of the sort we've just gone through are permissible to any degree at all, then to the degree to which they are permissible, insofar as they are allowed, your tendency to plan for the future and to not exploit and consume your property immediately will be hampered, and the converse tendency will be activated. That is, the tendency to consume, to immediately exploit and make use of your property. And the reason for this is that you know that if you do not immediately exploit it and do not make use of it as quickly as you can and consume it and derive all the benefits that are to be derived from consumption, someone else, namely the person doing the expropriation of your property, the person taking it away, will exploit it for themselves. So you create this dog-eat-dog environment where if you don't consume something first, someone else will. And so to prevent them from doing it, you have to do it. And this is a systematic tendency that is promoted by any degree of systematic violations of property rights that are allowed. So for example, if I own a plot of land and I am able to harvest my crops, and I retain full ownership rights to them and may sell them to whomever I like for whatever price I like and do anything else that I like with them, well, then I'm much more likely, A, to take much better care of the land that I own, because if its productive capacity lags in any way, the capital value of my land is diminished. I will be hurt by that. I directly will bear the cost. However, if I know that at a certain point some organization, the state or whoever else, will confiscate, let's say, 20% of my crop, well, then I'm not going to work as hard because less of that total yield is going to be available for me to exploit. And so if it were the case that I could retain ownership to the full extent, to 100% of the yield, I may work and invest the effort to produce a larger yield than I would be willing to work and invest the effort to produce if I'm only able to retain 80% or 50% or what have you. And as the percentage that I'm allowed to retain diminishes, so consequently my investment effort also diminishes. And so the economic consequences of this kind of systematic exploitation of property by non-owners, people other than the legitimate owners according to the criterion outlined above, previously I should say, will be a consequently diminished productive capacity. So that to the extent that you have any government intervention in the economy at all, you will diminish total economic productivity, inevitably. And the other consequence is that you will promote, to some extent at least, short-term consumptive behavior where people do not plan for the future, and you will diminish the incentive to be forward-thinking, to plan for the future, to save, to invest, to be prudent, to be provident, and so forth. And so one of the social consequences of any significant amount of exploitation of property by non-owners like the state over of legitimate owners of property will be to incentivize, frankly, cultural and social degeneracy. You will encourage people to live in the present, to think only of now, because it is only in the now that they're able to derive any enjoyment. Their capacity to be rewarded for efforts that will only bear their full fruit far in the future will be diminished if their property rights are not safe from exploitation by non-owners. So this is a very important sociological consequence of statism and state intervention in ordinary life and interference with people's property rights that Hoppe points out. And it's really a brilliant insight that to the degree to which the state monkeys around with property rights, to that degree it promotes degeneracy. And that is something that I think people on the right, especially on the alt-right, who claim to be concerned with these sort of things, should really think about very closely. I think that's all I have to say about property rights. Again, this is not a video I expected to make, but certain ideas, certain basic principles just appeared to me to be necessary to set down, so that if for no other reason, the people who are subscribed to me at least know where I stand on the topic. So that's all I have to say about that. If there's anything that's unclear or anything else, as always, feel free to leave your comments. All relevant links to everything else, as I mentioned, Hoppe's book here, which everyone should read. This is an excellent piece of work, as well as another book of his called The Economics and Ethics of Private Property, which I have but not on hand, so I'm not going to reach for it. And also Democracy, the God That Failed, which is sitting on a shelf there. Yeah, I'm going to put links to all of those, and also links to a few essays by Stefan Kinsella, so if you're interested in more details about what I've said, you can read them. That's it. Thank you for listening, and have a nice day.